Welcome to the JMJ Commercial Realty Podcast. Dive into market insights, winning strategies, and the stories shaping today's commercial real estate landscape. Let's get started.
Welcome, everyone, to the JMJ Commercial Realty Podcast. I am Adam Schertzer, a salesperson and advisor at JMJ Commercial Realty. And as always, I'm joined by the owner and broker of JMJ Commercial Realty, Josh Cedia. How's it going, Josh?
I am fantastic. How are you?
Awesome. I am great. And today we're going to talk about lease negotiations.
We are.
Yeah, which is a big part of the work that we do. If you want to just let people know if they're tuning in for the first time, kind of what is JMJ Commercial Realty?
Yeah. So JMJ Commercial Realty is a commercial real estate brokerage company. We are based in Needham, Massachusetts. We help landlords, tenants, buyers, sellers with commercial space. And we're generalists, so we cover office, retail, industrial, multifamily, land, all different types of things under the commercial space umbrella.
And I know a big part of our work is lease negotiations, whether it's representing a prospective tenant or representing the landlord with some of the spaces that we have available. So let's get right into it. Let's talk about how it works. Let's say we have a prospective tenant we're working with that's looking to lease property. What are some of the first things that we talk to them about when they're looking into this?
Yeah, well, if we have someone who has found, let's say, we've looked at a bunch of different spaces, and a tenant has found a suitable spot. We're helping them with tenant representation, for example. Typically it goes into a letter of intent. So at a high level, it's usually just a page or two, kind of business terms, how they're thinking about that space. And if the letter of intent or offer is accepted, those terms, and sometimes there's some negotiation back and forth before it could be accepted, but then that's used as the basis for a commercial lease. And oftentimes the letter of intent is not binding, but when you get to a lease and you sign off on a lease, then at that point it becomes binding. So
Mm-hmm.
it's at a high level, kind of what happens to get it into a lease, and then typically we see the landlord's attorney draft the initial lease.
Mm-hmm. And we usually see a lot of once we get that lease back, we have our client look it over. We look it over as well. Talk to them about it and see if there's anything on there that either they have questions about, or back, and usually they can be a little bit of a back and forth, right? It's usually not, or I can't think of any example where maybe one in the past couple of years where I've received a lease for a tenant that I'm representing, and they're like, "Yep, looks good. Let's sign it. Let's go."
Well, I do want to make the clarification here that we're not acting as an attorney. So when they receive that lease, sometimes a tenant will ask us if we can review it. And I'm happy to review it from a broker perspective or an advisor perspective, just at a high level, kind of what we
Hmm.
typically see with leases. But it really is a very good idea for them to have their own representation, their own attorney looks over it from a legal side of things.
Right.
But yes, there usually is, some back and forth on different items. So,
Yeah, definitely. And I guess what are some of the negotiation points that you see once we once we get a lease from the tenant side?
well, I think the more that you can outline things in the letter of intent clearly, the less um, you know, back and forth from a terms side of things. So like for example, expenses within a space, who's going to pick up the taxes, the insurance, the maintenance, some of those triple net expenses. If that's not clearly defined in the letter of intent, sometimes you move right into a lease, and then the lease will say, oh, the tenant is responsible for it. And the tenant looks at it and says, I don't want to pay those expenses. And if that, had been clear in the letter of intent, you know, maybe that would have been, one point, for example, that,
Hmm.
didn't have to go back and forth. Now, in terms of, the language of the lease, sometimes it's called like a red line, or we'll see like a lot of edits that an attorney will make. But usually that's just more on like the nature of the legal language protecting their client. But at a high level, some of the terms, some of the things that we might see is over, the lease start date, or when does rent actually start, or is there build out allowance or free rent, things like that. Sometimes those can be, or maybe there's a credit uh, based on maybe the HVAC system is not working, or there's different types of things that need to be done before a tenant can go into the space. So some of those items sometimes can, be reflected in a lease.
Hmm. Yeah, I'm thinking back to some of the deals that I've had and one that I have recently where maybe we weren't as clear or the terms weren't so well defined in the letter of intent. So now it's taking a lot longer in the negotiation point. I think, a lot of times you'll see in a listing, say base rent plus expenses, but the expenses might not be clearly defined. So you put in a letter of intent and say, okay, yeah, we're willing to pay you this base rent plus expenses. Um, but I think at that point, it's probably better for everyone just to get those expenses figured out before you even get the lease. So like, when you finally get to it, oh, okay, yeah, I knew I was going to have to pay, maintenance fees of X amount, or, I knew I would have to pay the electricity, but not the gas, or things like that, which can really add up. And some of these, especially triple net costs can almost be like another rent payment.
Mhm.
So,
Yeah. And then you look at things like price per square foot. Some landlords will say, when you lease this space, it's going to be 5,000 square feet and you're paying $25 a square foot, just as an example. Is it really 5,000 square feet? Sometimes a tenant will measure it and then they'll say, I measured this as 4,200 square feet. Where's the difference? And then that could get into, something in the lease of, well, what is the actual rentable square footage versus common area space? And so if you can kind of be clear about that, or if you could have a price that, is a dollar amount versus a price per square foot, sometimes that can clear away, you know, a specific square footage amount. Depends on the situation, but
mhm.
yeah, just trying to be clear up front, I think can really help a lot to make things go smoothly because different things are going to come up in any event with a lease. But if you get into the weeds in the lease, then you also have typically billable hours from the attorneys, and if you can do that before an attorney gets involved, that could be really helpful.
Yeah, definitely. Yeah, unfortunately, we do not have billable hours in our job. But yeah, I know what you mean. Sometimes there is a lot of that back and forth there. Um, and so I guess on the other side, say from, you know, a landlord, when a tenant comes to them, or say we're representing the landlord, how involved do we get with those leases?
Yeah, well, oftentimes, I guess it depends if you're dealing with a landlord who has a large portfolio of properties. They may be very skilled and have their lease that they are very comfortable using, and have their sometimes they have an in-house attorney, sometimes they have an attorney they've worked with for years. So sometimes it's a little more hands-off on the earlier stages while they kind of do what they need to do. Um, but we also have um, smaller landlords who maybe they just have one property or two properties and they need more hand-holding. And
Mm,
sometimes the landlord will ask, for a lease. I really try and defer to have them work with a commercial real estate attorney and have one drafted. Because again, we're not acting as an attorney or anything like that. But uh, there are different times when a landlord will ask for our guidance on something, how to be able to kind of work, with the tenant to try and make things happen. And sometimes, you have an agent that's representing the tenant, sometimes an agent representing the landlord, so you're working directly with the agent. Sometimes it's just the tenant directly. So different situations that come up.
mm.
What have you seen on the landlord side in terms of your involvement?
I think like you said, it really depends. I mean, I've had ones where, it's a management company or, that owns many properties. I'm thinking of one I had in Boston. And so they pretty much have, their boilerplate lease and they just have to fill in, you know, certain things here and there for whatever the tenant's going to be or for the building. Um, sometimes I find those are, sometimes you see these leases that are like 60 pages long for an office space, compared to, you might see one that's 3 pages long. And so, I think, like you're saying, it really does vary on who the landlord property owner is. I think if they are dealing with a management company, you might see um, something like that that's much longer. But I have one now where um, I'm helping someone lease out a few spaces in her salon, and she's not technically a property owner. This is a sublease, so this is her first time trying to rent out spaces. And even just from the initial conversations with her about, okay, this is how we're going to list it, this is you know what the agreement's going to look like, and now getting to the point where we have someone, and then trying to help her navigate, okay, we should run a credit check, basic things that you'd think that most property owners would know, but if it's their first time, they might need a little more help with this on evaluating the tenant coming in. um, so I think, like you said, it really depends on who the person is that's trying to find a tenant for their space.
Definitely. And sometimes we see situations where it's not a landlord directly, but it's the tenant that's there and they're trying to sublease some of their space. And maybe we have an arrangement with the current tenant
Hmm.
to help them. Maybe they don't need any of their space anymore or a portion of their space. So, there can be some nuances there as well. And certainly with a tenant, very often they need a lot more handholding.
Hmm.
Yeah. So each situation could be different, but I think at the end of the day, you know, typically a landlord has an empty space that they want filled. A tenant wants that space. They want to try and have it come together to work things out. Um, and as an advisor or a broker, you want to see that happen too. It's a good situation for everyone, but you have to be able to kind of step into the shoes of each party and kind of understand what's important to them and try and put something together that could work for both sides.
Yeah, and I know with what I've seen a lot too, certain tenants, whether it be that I'm representing on the tenant side or seeing their responses, um, most of the time, especially if it's their first lease too, they'll look it over and be like, oh, this is really in favor of the property owner, very landlord heavy, which I assume that's most of the case, just to protect the owner of the property. Is that something you see as well?
Can be, yeah. I mean, there are certain clauses that I look at, again, just as a broker, just kind of looking at it from that perspective. But like, for example, the ability to sublease, right? If you have a 5-year lease or a 10-year lease at a property, if something were to go astray and you basically want to be able to have someone else go into that spot, do you have the ability to put a new tenant in there to take over the rent payments? And if the clause says there is absolutely no subleasing, at this space, um, that's really not a pro tenant type of language. But if it says, yes, you have the ability to sublease, but the owner needs to approve, and it's not going to be unreasonable, for the owner, some language, something like that, that's a more typical type of clause that we see in there. Um,
Hmm.
so there could be something, you know, just with experience, as you're seeing a lot of these different leases, you start to kind of get a feel for, okay, this is really tips the scales more towards the landlord side, or this is really a tenant, more on the tenant side of things. But oftentimes it's the landlord or a seller, their attorney that starts with the initial lease. Sometimes a landlord, if perhaps they don't want to pay for an attorney to draft a lease, they might say, "Oh, can you just have the tenant prepare a lease?" Well, if the tenant has an attorney, which typically they do, their attorney is going to draft a lease, and it may be really tenant friendly because they're having their attorney start with that version of it. So
How often have you seen that? Because I don't think I've seen that where they've asked for the tenant to draft the lease.
it's rare, but I'd say maybe 5 to 10% of the time, maybe. Yeah,
Okay. So you have had that happen before then.
yeah, multiple times, but
Yeah.
not as often.
Okay.
And when that happens, it's usually a smaller operator, perhaps doesn't want to pay for an attorney's
Mm.
time to prepare something.
Yeah. Have they ever asked you to prepare a lease?
Yes. And within, at least in Massachusetts here, there are some pre-filled type forms that you can provide. So there is like a basic commercial lease, but each property, like we've said many times on this podcast, each property is so unique and situation is unique that
Mm.
yes, it's, you could use a generic type of lease, but what happens if something goes wrong, right? In a situation, you need to look to the lease as to what it says, and if it doesn't cover that situation, that's where it can get a little tricky sometimes.
Hmm.
So, um, I think it's best if they just work directly with an attorney to prepare something. I mean, think about like COVID, and some of these other situations that can come up, like what happens if we have another situation like COVID? Are they expected to pay their rent? Do they have a clause to get out early? You know,
Hmm.
now other types of situations, how often are these things being adjusted in a lease or reflected?
Yeah, definitely. And I'm thinking of some of the other points that people kind of bring up during that lease negotiation. And something I've seen a lot is kind of like a get out clause, or what happens if the company goes bankrupt and they can't pay anymore. Um, so whether or not you see a lot of times that the landlords want a personal guarantee. So even if XYZ company went bankrupt 2 years into a 5-year lease, that someone would still be personally responsible to pay for that rent. Um,
Right.
and I
Yeah.
know a lot of times the tenants don't want that, because then it's like your business fails, you're on the hook for, you know, X number of payments over the next couple of years, and you're paying for something that you can't make money on.
A
Um,
tricky situation for the tenant. But sometimes the landlord, I mean, to go back to supply and demand, if there's not a lot of properties out there that are suitable and the tenant really wants that property, and the
mhm,
landlord say, I have this premium location and this is a great spot, they might say, this is what I'm doing. It has to be a personal guarantee. Otherwise I'm just not going to lease it to
yeah,
it.
yeah.
Um,
And I think kind of on a side note, something that I didn't know about till I got into this job is, why sometimes you see properties that stay vacant for years. And you come to find out that, maybe someone had a 10-year lease there and they're still paying on it. So where's the motivation from the landlord to find a new tenant if they're still making money?
And especially if they're getting a good price per square foot, if it's a high rental rate, they may not be so keen to have a new tenant in there paying less, or a new tenant in there that, doesn't have a corporate guarantee. Maybe it's a
Hmm.
startup and it's a little riskier on that front. And there's certainly situations, there are things that you can do to help mitigate that. Maybe it's, a new company that comes in, but it's still backed by that previous tenant. At least it kind of like, allows them to not directly be paying rent, but just kind of being backing it up for a period of time. So,
Hmm.
different situations that could come up. But yes, sometimes to the general public, you look at an empty space and you're like, why is that? It's a great location. Why has that been sitting empty for 3 years? There's probably a reason why, there's probably someone who's still paying rent, whether it's a company or an individual, to that spot.
Hmm.
Or sometimes it's a redevelopment situation. And like, let's say you're a landlord and you have a tenant, you're providing a lease to a tenant, but you're thinking at some point in the future, maybe, there's a big project that's happening in the area, or you might want to redevelop your property. You know, uh, it might be really important for you to have a redevelopment clause in your lease. A tenant probably doesn't want to see that, but if you're the landlord, you want to be able to have that, because if someone wants a 10-year lease, just as an example, and 2 or 3 years into their lease, you want to redevelop the project. If they have that longer term lease in place, it can make it quite difficult for you to move forward with a redevelopment project.
Yeah, definitely. Yeah, a lot of things to consider there on both sides. Before we kind of wrap up here, is there anything else that you wanted to add about lease negotiations?
Well, I think working with an advisor or a broker can be very helpful, whether it's, landlord representation or tenant representation. If you're working with someone who has a lot of experience in these types of situations, and you have to look at, within commercial, if we're talking about an office transaction or or a retail transaction, there are certain things that are more important for certain types versus others, whether it's signage or parking or ceiling height or other types of things, or what's customary in a certain market. I think an advisor or a broker can really add a lot of value in those situations. So something to keep in mind. And a lot of times for the leasing side of things, let's say it's a tenant representation. Oftentimes the landlord is paying the commission costs for working with a tenant agent, so could be able to have guidance as well as the commissions often can be covered by a landlord. So something to
Hmm.
consider on that front.
Yeah, definitely. And I think I found too with a lot of the properties where we're representing the landlords or owners, there's not always a tenant rep. A lot of times some business might just look online and find it themselves and just call us up. Um, and I know in those situations, we definitely, try to help them out with, letter of intents and things like that. But there's only so much we can say, on that side because we're not representing them as well in those situations. Um, and I think there's definitely times where the tenants would benefit, like you said, from having someone representing them and looking out for them, whether it, advocating for, maybe a lower rent or free months or things like that, that maybe someone wouldn't even think to ask about.
Mhm.
Um, so I think that I've seen that it's very helpful having someone, and like you said, a lot of times the landlord, the owner will pay our commission, but even in instances where they don't, um, there's times I think with we can save our clients money even with paying our commission. Yeah.
Yes, thousands
Yeah.
and thousands, if not
Yeah.
sometimes hundreds of thousands of dollars, depending on the
Right.
situation. So, yeah.
Right. So there's definitely a benefit there. So don't go it alone. That's the advice we have.
No, but I hope it's
Um,
helpful, just even for someone listening, whether
yeah.
they're, new to this or they're experienced or they're in the business, we want to try and provide a valuable resource with this podcast. And we certainly are happy to help if people have questions. You can just email us at podcast@jmj-cre.com.
Hmm. Yeah, definitely. Or leave us a message in whatever platform you're listening to this to, and we will get back to you in a timely manner. But I think that about wraps it up for this episode. Josh, thank you for your time this morning.
Yeah.
And thank everyone for listening, and hope to connect with you in a future episode.
Take care, everyone.
All right, see ya.
The views, thoughts, and opinions expressed on the JMJ Commercial Realty podcast are those of the host and guests and do not necessarily reflect the official policies or positions of JMJ Commercial Realty or its affiliates. The information provided in this podcast is for informational and educational purposes only and should not be considered financial, legal, or real estate advice. Listeners are encouraged to consult with qualified professionals regarding their specific real estate or business needs. JMJ Commercial Realty makes no representations or warranties as to the accuracy, completeness, or suitability of any information discussed. Reliance on any information provided in this podcast is done solely at your own risk. By listening, you agree that JMJ Commercial Realty and its representatives shall not be held liable for any losses or damages resulting from the use of information shared.